So you've come up with something new, perhaps some new branding or some new creative work like some artwork, or perhaps some new software or some new recipe, some new product, whatever. You've come up with something new, and the question is, how do I legally protect whatever it is that I've come up with? That question of how do I legally protect whatever it is that I've come up with is the legal realm of intellectual property, or IP for short. Hello and welcome. This is intellectual property lawyer Eric Kelly. In this video, we'll go over the main types of intellectual property tools that are used to protect various new things that you might come up with. This video will help you to understand which intellectual property tools might best serve to protect whatever it is that you've come up with. This video will touch on 5 main flavors or types of intellectual property tools, which are 1. U.S. patents, 2. U.S. copyrights, 3. U.S. trademarks, 4. trade secrets, and the last one, the 5th one, are publicity rights. And people often get what's protected by patents, trademarks, or copyrights confused. So hopefully this video should clarify such issues and such confusion. First, let's discuss U.S. patents. U.S. patents protect new and non-obvious inventions. So if you've come up with a new product that is tangible, that is a new product that one can physically touch, then you immediately should be thinking of a U.S. patent for protecting that new product that you come up with. Tangible products can be anything that you can physically touch and or that actually exist in the real world. There are literally millions of examples of tangible products, ordinary things like a screwdriver or screwdrivers to more complex and unusual things like submarines. The examples are endless, basically. However, if you've come up with some sort of new product that can be physically touched, if built or made, that does not mean you actually have to build or make a prototype in order to get a U.S. patent. You do not have to make or build a prototype in order to obtain a U.S. patent on whatever new product that you've come up with. However, to obtain a U.S. patent on whatever new product that you came up with, a written patent application that shows, describes, and claims the new invention, the new product, has to be timely prepared and filed at the U.S. Patent Office, what we often call the USPTO or the PTO. Also note there are 2 different types of U.S. patents that can protect your new product. There are U.S. utility patents and there are U.S. design patents. U.S. utility patents often protect how the new product works, is made, and or how it's used, whereas U.S. design patents protect how a new product looks. U.S. design patents protect the unique exterior look of a given new product. But what if the new product that you've come up with is intangible? That is, the new product cannot be physically touched. For example, perhaps such an intangible product might be software, such as but not limited to a graphical user interface, or what we sometimes call a GUI. Maybe it's some sort of digital asset or digital rendering, or some sort of other software. So software, regardless of what type it is or what it's doing or how it looks, can sometimes be protected by U.S. utility patents, by U.S. design patents, by U.S. copyrights, or by trade secrecy. So it really depends there. There's a lot of nuance. A graphical user interface, or a GUI, might be protected by a U.S. design patent, by U.S. copyright, or even possibly by a U.S. utility patent under certain situations. If a digital asset has an associated on-screen image or rendering, then the image as artwork of that digital asset might be protected via a U.S. copyright and or possibly by a U.S. design patent. In any event, if you've come up with some kind of new product, whether it's tangible or intangible, first think about protecting that new product with a U.S. patent. Talk to a U.S. patent lawyer that is a patent lawyer that is registered to practice before the U.S. Patent Office, before the USPTO. And with respect to U.S. patent, here's an extremely important rule to remember. Your patent application has to be prepared and filed within 1 year of you first making your new product publicly disclosed and or publicly available. So if you wait too long to have your patent application filed, more than a year past one of those first public disclosures or public availability dates, you will lose the ability to obtain a U.S. patent on your new product. If you are to remember anything in this video, try to remember that 1 year grace period rule. Okay, next, let's consider another separate category of intellectual property tools, which is U.S. copyrights. U.S. copyrights protect creative works that have been authored, created, or made by humans and not made from other animals or made from AI. So it has to be a creative work authored or created by a human. And creative works can include all sorts of things. So some examples are, one broad category would be literary works. This is essentially written works, so things like novels, short stories, poems, scripts, screenplays, written blogs, anything that's in writing form and that's long, longer, than just a few words might be protected by U.S. copyright as a literary work. Another big broad category would be visual arts. So this can include, all types of artwork, two-dimensional artwork, 2D artwork, photos, photographs, digital photos, 3D or three-dimensional artwork, sculptures, 3D printed artwork, even things like jewelry. That would be like a type of 3D work, like a sculpture. So any of those visual arts are things that might be protected by U.S. copyright. Another category of creative work would be sound recordings. So that could easily apply to music, but there could be other types of sound recordings as well that might be protected as a creative work that might be protected by U.S. copyright. Another kind of broad category of creative works that are protected by U.S. copyrights includes things like motion pictures, videos, animations, movies, video blogs, and things of that nature. And another broad category would be choreography and or pantomimes. Those are also examples of, or a category of creative works that may be protected by U.S. copyrights. And then the last common category that we often talk about are performing arts. And these different categories can be mixed and matched as well. You could come up with a creative work that has elements of one or more of these different categories. And in order to enjoy the full protections under the law, copyright in a given creative work must be registered with the U.S. Copyright Office. So that's really important to remember as well. If you're coming up with creative works which are going to have copyrights attached to them, you really want to get into the habit and learn how to register the copyrights in those creative works with the U.S. Copyright Office. So if you've come up with some sort of creative work, such as any one or more of the examples I've just noted or something similar to those, there's a good chance that U.S. copyright law may be the way to go for protecting your new creative work. Okay, next, let's talk about another category of intellectual property tools, the category of trademarks. And this is our third category. Legally, a trademark identifies for consumers and for the public who is providing a given product and or a given service. So let me give you an example to make sure that helps make a little bit more sense. For example, when you see the Nike swoosh, then you immediately know it's a Nike product. That is, you immediately know upon seeing the Nike swoosh on some shoes or on some clothing that the given marked product is made by Nike. So in that example, Nike is the source. The trademark identifies the source of the given product and or the given service. For simplicity, you can think about U.S. trademark law as protecting brands, branding, and or brand elements. For example, the following branding elements are often protected as U.S. trademarks. So the first example there would be logos. Logos are often protected as U.S. trademarks. Product, service, and or company names, so the names of a product, name of a service, or even the company name itself, those also often are protected as a U.S. trademark. And the product, service, or company name, that can be one or more words. And those words that are the product, service, or company name, they are often sometimes made up words. That's also perfectly fine in the realm of trademark law. Other categories of brand elements that might be protected by U.S. trademarks include mottos or taglines, and sometimes even things like colors, even sounds, or even smells can be a brand element that actually operates as a U.S. trademark under certain circumstances or conditions. Any branding element that you can think of under certain conditions might be protected as a U.S. trademark. But the most common examples are going to be logos, and then the company name, the product name, or the service. Those are the most common examples for things that are operating or being protected as a U.S. trademark. In order to enjoy the full protections under the law, the given trademark should generally be registered with the U.S. Trademark Office. There are something known as unregistered or common law trademarks, but they could have less protections under the law as compared to a U.S. federally registered trademark. So federal registration of the trademark is often desirable when possible. Even unique and or distinctive objects can function as part of the branding, and as such, may be protected as a U.S. trademark. And specifically in this category or subcategory, something we call trade dress. A trade dress is often like the shape of like a product or product packaging, and that can actually be a type of trademark. For example, the classic Lego block, that shape of the classic Lego block is protected as trade dress. And trade dress, again, is just a subcategory of a trademark. And again, in order to enjoy the full protections under the law, a U.S. federal trademark registration application might be filed with the U.S. Trademark Office seeking registration of the given trademark or trade dress. So if you've come up with some sort of branding, such as the things I've noted above, there is a good chance that U.S. trademark law may be the way to go for protecting your branding. Okay, next let's talk about another category of intellectual property tools, the category of trade secrets. This was our fourth category. Trade secrecy means you are protecting whatever it is that you've come up with by keeping certain details secret and confidential. The classic examples of trade secrecy protection are for the secret formula for Coca-Cola or the secret recipe for Kentucky Fried Chicken or KFC. So secret food and or beverage recipes and or formulas are often protected as trade secrets. That's very common. If you've come up with some sort of new food or beverage product, then there's a good chance that you're going to be looking at protecting that as a trade secret. Another trade secret example would be dealing with software. So for example, the raw programming code for some given, piece of software might be protected as a trade secret by keeping that raw code a secret. That is, in the software that is publicly released, it's often in a form that's been compiled or otherwise in a state where its raw programming code is not known by its users. And therefore, the raw code that makes that software is being protected as a trade secret. Other trade secret examples often include things like customer lists or supplier lists. Basically, anything in your business that you keep confidential or secret can be protected as a trade secret. To establish a trade secret, you have to develop protocols and practices within the business that are specifically designed to keep whatever it is that you want secret. So that might be using non-disclosure agreements, keeping recipes or formulas locked in safes, or only having certain employees that have access to certain things, or actually breaking the secret into multiple parts and storing different parts of it in different locations, etc. There's lots of different ways of doing it, but you have to put in place various protocols and systems for maintaining the secret. However, there can be, vulnerabilities to using trade secrecy protection. Basically, that is, if someone learns the secret, someone that wasn't supposed to know the secret, if they learn it, then the trade secrecy protection goes away. So because of that, trade secrecy protection can be vulnerable to reverse engineering and or industrial espionage. However, in the case of industrial espionage, if you can prove that, then you may have basically a lawsuit claim for what we call misappropriation of a trade secret. So someone can't just blatantly break into your company and steal a secret. However, they can buy your product and try to reverse engineer it. That's perfectly fine. In any event, trade secrecy works only as long as a secret remains a secret. For example, the law requires that food or beverage products have labels that basically list all their ingredients. So that can make it easier for a food engineer to reverse engineer some given food product or beverage product. However, even in that situation, the food engineer is trying to do the reverse engineering. They're not going to know the exact formula or recipe of the original food item that they're trying to copy. That's why there's many different clones or copies of Coca-Cola, but none of them taste exactly like Coca-Cola. And pretty much just anyone can tell the taste difference between the authentic product and the knockoffs. Now, with respect to software being protected as a trade secret, that's always, at least in my mind, is vulnerable to a competitor, that's using a competent programmer and or developer. They can build their own software that basically does the same thing as the protected software without violating the trade secret. So that's another way where it can be software that's protected by trade secrecy can be vulnerable because someone can do a workaround, basically come up with different software that does the same thing, and that would be a viable workaround. Additionally, as our technology base gets more advanced in general, reverse engineering capabilities are only going to get better and better. So trade secrecy for long-term viability may have limited success when it comes to protecting things like food or beverage formulas or even software as we move forward in the future, particularly far out in the future. Okay, we've made it to the last main category of various intellectual property tools, which are publicity rights. Publicity rights are state laws that do vary from state to state. For example, here's a portion of California Civil Code Section 3344, which states in part, any person who knowingly uses another's name, voice, signature, photograph, or likeness in any manner on or in products, merchandise, or goods, or for purposes of advertising or selling or soliciting purchases of products, merchandise, goods, or services without such person's prior consent shall be liable for any damages sustained by the person or persons injured as a result thereof. Yes, that's a mouthful, and that's just a mere portion of that particular law. But the gist of that law is that another cannot use your name, voice, signature, photograph, or likeness without your permission for essentially commercial purposes. And in California, there are also versions of this law that even protect someone after they've died, or more technically, such publicity rights laws, and at least in California, protect the deceased person's estate for some number of years after the death of that particular person. So California has publicity rights laws that protect the living and that protect the deceased. One of the reasons why deceased persons' estates have publicity rights is that their name or likeness can be really valuable. And a prime example of that would be like Michael Jackson. His estate still produces and generates, millions and millions of dollars every year. So that's a valuable intellectual property asset that needs to be protected. Now, California's publicity right laws are fairly strong, in part because they initially evolved to protect the celebrities that were associated with Hollywood and the movie industry and the music industries. And other states' publicity rights laws may be less strong as compared to California versions, so it can vary significantly from state to state. But the main implications of such publicity rights laws are that you never want to use someone else's name, voice, signature, photograph, or likeness without their permission for commercial purposes. Because if you do, you could be liable. That means you could be out legally on the hook to have to pay them money. And so conversely, if someone uses your name, voice, signature, photograph, or likeness without your permission for commercial purposes, then they might end up owing you some money, at least, if you sue them and win that lawsuit. Lastly, let's briefly talk about the possibility of overlap between these various different intellectual property tools. Depending upon the nature of whatever it is you've come up with, sometimes two or more of these different intellectual property tools might be used to protect whatever it is that you came up with. There can be some overlap among these various intellectual property tools in some situations. For example, consider a new logo that you've come up with. Now, if you're planning on using that logo in your branding or as part of your branding for some product or service that you provide, then U.S. trademark law might be used to protect that logo because you're using that logo as a trademark. But additionally, on top of that level of trademark protection, that logo, depending upon how it actually looks, might also be an example of creative artwork. And if that's the case, then U.S. copyright law might also be used to protect that logo as well as that layer of trademark level protection. So with the new logo example, copyright law and trademark law might be applicable there. Or another example, let's say you've come up with some unique packaging. Now with unique packaging, perhaps that unique exterior look of that packaging might be protected as a U.S. trade dress. Or in addition to U.S. trade dress protection, perhaps the unique look of your packaging might be protected by a U.S. design patent. Or in addition to, perhaps the way that your unique packaging works might be protected by a U.S. utility patent. So in this particular example with unique packaging, you might have U.S. trade dress law protection, you might have U.S. design patent protection, and you might have U.S. utility patent protection. Or another example, let's say you came up with some new and unique jewelry. Now that jewelry might be protected under U.S. copyright law as essentially 3D artwork as a sculpture, and the unique look of that new jewelry might also be protected by a U.S. design patent. So as you can see, depending upon the nature of whatever it is you've come up with, sometimes two or more of these various different intellectual property tools might be used for protection. Okay, this has been U.S. intellectual property attorney Eric Kelly, and I do work with clients from all over the world and all over the United States. And I am a copyright lawyer, a trademark lawyer, and a patent lawyer. So as we saw in this video, copyrights deal with protecting creative works, literary works, visual arts, music, things of that nature. Trademarks protect branding, logos, the names of products, services, or company names. And patents protect new and non-obvious new products. And then lastly, here you can see my contact information, phone number if you want to text me, and emails if you want to email me if you have any questions. And feel free to reach out to me. And thank you. Please like this video and subscribe to my channel to help me reach others about intellectual property matters. And here's some of my suggested videos on various intellectual property topics. Thank you and bye.